I would like to welcome you in today's Malawi Crime Podcast. Today we still have Molis Chapola, who is the Northern Region Public Relations Officer. You are most welcome in today's program, Mr. Chapola.
Thank you very much.
And today's program, we are going to discuss on grievous harm offences. So we would like to urge you, the listeners, to listen and also to be part and parcel of this program. What is a grievous harm offense?
Well, in the first place, let me say that it is ideal probably to know and be in the know of what different offenses are and how we can sin ourselves behind bars for committing such kind of offenses. We should get to know that ignorance of the law is not a defense. Once somebody has been taken to task and has been arrested by the police and has been brought before the court, it will not be a mitigating factor if same is being said to the magistrate or the presiding judge that I committed such kind of an offense because I was not in the know. I did not know that doing same could amount to an offense. That is why it is important probably to understand what constitutes a crime and what are the points to prove that an offense has been committed. Taking you through the issue to do with the matter at hand, which is grievous harm, which infringes Section 238 of the Penal Code. It is very clear that if you unlawfully does grievous harm to any other person, that particular person shall be guilty of a felony and shall be liable to imprisonment for a period not exceeding 14 years, depending on the presiding magistrate. It may be under the jurisdiction of the court, probably to usher a maximum sentence or at least to decide otherwise. So when we talk of grievous harm, it has been defined as any person who unlawfully does grievous harm to any other person shall be guilty of a felony and shall be liable to imprisonment for 14 years. That is an extract from the Penal Code under Section 238 of the same Penal Code. Remember that when we talk of the Penal Code, it is an extract from the laws of Malawi, which is the Constitution, the supreme law of the land. We have always said that the supreme law of the land in the Constitution has always said 1,000 times that any law that happens to be in conflict with this particular law is deemed to be incompetent and it cannot be as a law because the law itself gives something of protection to human rights. And the human rights includes liberty, perhaps to life, to education, to everything. But you would understand that the premise of this particular section 238 of the Penal Code, which at least talks about grievous harm, knew that some of the rights may be infringed, probably deliberately being done by the perpetrators. That is why they decided that if it happens that somebody has been injured, to the extent that he has been injured and he becomes unable to at least enjoy the rights as captured under the Constitution of Malawi, that particular person of the perpetrator should not go freely without being punished for the acts that have been committed.
Thank you. Molis, what's the difference between a grievous harm and wrongful? Because this offense is an element of injuring someone. So how can the viewers have the real difference of these two offenses?
Yes, that is very true. That wounding as well as grievous harm, they are all assault cases. What differentiates the two is the aggravating factors surrounding how the offense was committed. Because if you say unlawful wounding, it means, as the vocabulary itself, the victim should be unlawfully wounded. Unlawfully wounded in the sense that if somebody has been wounded lawfully, it does not perhaps be taken to task for wounding that particular individual. One would question, how would someone lawfully unwound a person? You would understand that one has been taken to theater rooms at any hospital where the doctor in the process would at least administer some wounds. That is lawfully wounding. That is not an offense. But in the event that somebody takes a panga knife and eventually it lands on somebody and he has been cut where blood is oozing, that particular person can be charged of unlawful wounding. But when we talk of grievous harm, it means the victim will automatically suffer deformity. Somebody has been injured to the extent that he has lost teeth. He has probably rendered that particular victim to be amputated in the event that he has been taken to hospital. It means that person has been grievously harmed. The gravity of that injury, which has been classified as grievously harmed, would transform the matter from just being unlawful wounding to grievous harm, because the deformity would be marked for lifetime. Because if somebody has been rendered amputated at the end of the act that you have caused, you will no longer see that particular person enjoying the use of that body part which has been amputated by the hospital personnel in the event of saving his life. But the injury has come just because you orchestrated that particular move. It will automatically say that that particular person has been at least deprived of his rights as stipulated under the Constitution of Malawi, and as one way of ensuring that there are checks and balances towards him. That is why the framers of this section 235 thought it wise that any harm that is aggravated in nature should be termed as a felony in nature, as witnessed by its maximum sentence, which is also seen to it that in the event one has been proved that has committed the offense, that particular person can live behind bars for a period not less than 14 years. As I was taking you through, there are other acts which on their own they can be fashioned to cause grievous harm. Those acts cannot be just detained, but needs to be at least given close attention so that one question is taken to task, knowing that such acts may include probably taking substances or anything that may end up causing harm to that particular individual, the victim for that matter in this case. And in the event that you may do something unlawfully that may throw or bring some liquid for that matter, some liquid you may talk of as which eventually may bring permanent disfigure to that particular individual. You may also be taken to task for causing grievous harm. And in the event whereby you may prevent the detention or any lawful arrest and cause deformation to the person that is affecting that particular arrest, you may not also be taken to task, and if the court finds you guilty, it may please the court probably to give you life imprisonment.
So Molis, how serious is the offense of a grievous harm?
I would quickly say that the offenses of grievous harm are very serious in nature, as witnessed to the sentence or the maximum sentence as attached to it. You would agree with me that we have had a discussion where we understand and discover that death penalty or life imprisonment is attached to cases that are more serious in nature. Grievous harm cases can attract life imprisonment. By seeing at the sentence itself, one would tell that causing grievous harm is really a serious nature as provided for in the penal code. Knowing that we are talking of an individual who was born perfect, but following your act, particular individual turns to be disabled, the law will not let you go freely. It may please the presiding magistrate to see to you that probably you have to spend the rest of your life behind bars, so that at least taking you away from society could be something that would send a signal to the offenders. At the same time, you need to reform yourself behind the bars, because you can also reform yourself behind bars, that you can become a good and useful citizen whilst in prison. We have seen people preaching whilst in prison. We have seen people becoming good counselors behind bars. So it will not only be focusing on seeing you behind bars for life, but probably a difference has to be registered. Remember when we talk of waste offenders, where it is said that waste offenders are due to be handled with maximum sentences. Maximum sentences in the sense that these other maximum sentences are capital in nature. We should always understand and score that justice should always be there, that the aggravating factors of the offense should be taken on board, and they are outweighing the mitigating factors that may be given by the suspect during the court appearance. You would understand that most presiding magistrates have always said that when it happens that you have that intention to commit the offense, there is no say that I'm a breadwinner, probably I'm a husband to somebody, I'm a wife to somebody, but only when you are appearing before the court, you do move the court that I need at least a lenient sentence, knowing that I have responsibilities out there. One would ask, when you are committing those offenses, were those responsibilities not behind you? Were you not able to understand that if I commit such kind of offense, I may end up being jailed? What could be the reasoning out of that? That's why we have seen so many cases, despite that mitigating factors may give to it that they are breadwinners, but magistrates have eventually sent those perpetrators to jail. So you do understand and see to it that there are other issues that may put issues to do with grievous harm to be more dangerous, how they are committed. For example, under Section 237 of the Penal Code, it is indicating where issues to do with grievous harm is being committed by at least endangering the safety of persons traveling by railway. Remember that if that particular grievous harm has been caused by either intention or recklessly, endangering or tampering with the railway, the law will not let you go freely. And the law under section 237 of the Penal Code will automatically say to you that you are imprisoned for committing a felony. How this offense can be committed can be in a number of ways. One would think that putting other objects on the railway would not affect trains when they are about to cross that particular object. But eventually, if it is discovered that those objects which you have put across on the railways, they have caused injury, and that injury would be classified as deformity or serious in nature. Serious in the sense that it is departing from lawful wounding and the common assault. It will definitely see to it that you have to be charged with this offense, which is known as grievous harm, which has also been defined under section 238 of the Penal Code.
Molis, thank you very much. You have also tackled into the issue of common assault. So, what is the difference between common assault and a grievous harm?
Yeah, that is very true. As I said in my preamble, that grievous harm, lawful wounding, and common assault, they are all assault cases. They all belong to the same family of assault cases. But what differentiates them is the issue to do with the gravity of the offenses and the elements attached to them. Let me quickly say that common assault can be taken as an assault which is not aggravated in nature. We have seen that people have always used common assault to their advantage, perhaps to keep their children upright. You would understand that there is a cry out there that people have always mentioned that children are being subjected to cruelty when they are probably administering what is known as justifiable assault by parents. Because parents would quickly say that I'm advising and I'm trying to make my children become morally right by, among other issues, using what is known as the corporal punishment on a soft note, whereby one will understand, myself, yourself, and the listener out there, that during our time, parents could whip us probably any time they feel like we have done something to the contrary to what is expected morally. That could be named as justifiable assault. But in the event that that justifiable assault has been aggravated and the child has been injured in the process, and that particular person is bleeding, it will switch and change terms from common assault, rather justifiable assault, to different issues altogether. But what differentiates them might be the outcome in the hospital. Remember, when somebody has been assaulted, it is the duty of the police, which in normal circumstances becomes the stage when this matter is being taken before the court. The state or the police would wish a medical form to the victim, where medical practitioners, after examining the degree of the injury, would furnish the police with the outcome, may indicate where a medical report indicates that the victim has suffered tissues. It means that particular person will be treated as he has been commonly assaulted, and that perpetrator in the same thing would be arrested for common assault. Common assault is a misdemeanor, whereby somebody who has been charged with common assault can be released on police bail, and they may be attending court sessions or operating from home. But in the event the medical report indicates that that person has suffered injury and has also suffered open wounds where blood was oozing from those particular wounds, that person would be charged with unlawful wounding. But where it has also indicated that there is permanent disfigure, that person would be charged of grievous harm. So permanent disfigure is something more serious, and that is why the law itself has also attached a serious penalty of life imprisonment, so as to understand that people are always cautioned before they commit such kind of offenses.
Who are the most victims of these offenses of grievous harm between men and women and the youth, and why?
Well, we quickly say that issues to do with grievous harm are also having roots gender-based violence, where in the instances where this matter has been tapped from gender-based violence, the most victims becomes women and children, because men becomes by culture. They feel like they are controllers, they are breadwinners, they can take charge of everything, and they are the perpetrators of gender-based violence. And having that in mind, you would understand that most of the victims, when it comes to gender-based violence, perpetrated grievous harm, the victims becomes these two as vulnerable groups. But there are special occasions where grievous harm has been originated from either drinking joints. You would understand that most drinking joints are patronized by men, where in the instances people may end up being involved in a fight. So men becomes the victim of grievous harm, depending on the originality of that particular grievous harm. So I would quickly say that circumstances and where these things are being originating from would classify who would be the victims depending on the issues at hand. So one would say that in the event that matters to do with grievous harm are originating not from the roots of gender-based violence, it will mean that men becomes at least the most notable victims. But where issues are originating from gender-based violence, men and children, rather women and children, are the most notable victims.
But how serious is the offense of? I've already asked you that question. What are the penalties for the offense of a grievous harm?
Well, as I said, that grievous harm is classified as federal in nature, and is being classified as one of the most serious offenses under the Maori Penal Code. Knowing that grievous harm in other circumstances, on special circumstances, it has a maximum sentence of life imprisonment. Unlike what is stipulated under Section 238 of the Penal Code, where it has a maximum sentence of 14 years imprisonment. Remember that the presiding court or presiding magistrate or the jurisdiction itself would quickly see to it that the factors surrounding the deformation that may be encountered by the victim would be the aggravating factors that would move the court probably to make a stiffer sentence, a sentence that would at least see to it that everyone would understand that indeed this particular suspect was supposed to dance to the tune, knowing that these other previous offenses are caused or deliberately put on by issues to do with interest. It might be interest probably to injure the society, probably to score either political mileage or anything that one might have before committing the offense. Remember, we talked of issues to do with injuring persons by tampering or putting or obstructing a railway. There might be other factors that may fall. Injuring those on board, probably trying to cause some miscomfort amongst the residents where that particular railway is going through, or probably bringing some havoc in the political temperatures, where one would say they are destroying what would have been property for the nation. So if those factors have been taken on board, the presiding magistrate may think otherwise, and he may think that probably this is the right time that we give strong sentences that would at least send a signal to the offenders, depending on the circumstances or issues that have been put on across by the presiding magistrates. Remember that in the event that such aggravating factors have been considered deeply, the perpetrator may be handed life imprisonment, which is a capital punishment. So a capital punishment would only serve as to say that that particular offense is serious in nature. So in the event that somebody has been classified as a serious offender and has been classified as somebody who has been committing such offenses of grievous harm every now and again, that person can be handed life imprisonment as a maximum sentence.
Wow, thank you. Thank you very much for your time, and I'm not taking this time for granted. Thank you very much.
Thank you so much.
Thank you.